Good day, everyone. Welcome to the Legal Lounge with me, Sophia Bryan, principal attorney at the Law Boss firm based in Kingston, Jamaica, where we help Jamaicans at home and in the diaspora build and preserve their legacy through real estate and estate planning. So, in the Legal Lounge today, I'm going to be looking at various scenarios when it relates to real estate and estate administration. So I have quite a few scenarios, and you will also have an opportunity to ask me questions about any particular legal situation that you may have. Bear in mind, it's not legal advice and it doesn't constitute attorney-client relationship. I can speak generally if the context, where the context allows for me to do that. So I'd love for you to share the live if you know anyone that might be interested in having some questions answered or getting some information around land related, probate, estate related questions. I'd be happy to offer some general information where the context allows. So I am trying to figure out how to allow people to come on other than them requesting, and it appears that it's not so intuitive, but I know persons can request to come on and I'm able to allow them to come on. I know there's a feature that allows people to be able to click on a box and come on. Anyhow, giving TikTok a few moments to spread the word. And of course, I'm already sweating. It's okay. All right, so I'm gonna be sharing questions around real estate and estate planning. And I'm gonna go to the first scenario in just a moment. Oh Lord. So as I said, if you have any questions that you'd want some clarity around, feel free to request to come on. I'm going to get into the scenarios I have pre-planned to discuss in a few moments. All right, cool. All right, so the first scenario that I have for you. All right, so without a will, the estate must, let me go back. So, in a situation where somebody's grandfather passes away and leaves land for a lot of grandchildren and children, however, there's no will and no everybody wants a piece. What happens in a scenario like that? Right? So, it's a very common issue in Jamaica. Incidentally, a lot of the homicide cases in rural areas in Jamaica actually have a lot to do with dead left, as we refer to it in Jamaica. And it usually spans, it comes up from the fact that the persons that own these things typically don't have a will in place, and so persons are left to figure it out. So in Jamaica, If you don't have a will, the law has already established how your assets are supposed to be divided. And it starts off with your spouse being at the top, children, and then it goes down in a certain order, right? And so if a granddad or a patriarch, for example, passes away and does not leave a will, it's left up to the children to administer the estate and go through that process, right? And so if they have, for example, 5 to 10 children, maybe from several different families, or they have multiple families, everybody has to come to some type of agreement as to who the individual will be that will apply for letters of administration. Oftentimes, that is either the eldest person, or the person who demonstrates the most leadership capacity in the family, or sometimes it's left on the person who everybody regards in the family as the bright one. But whatever the decision is, everybody has to be in some type of agreement, because what you don't want, which I've seen, where one set of children decide to go through the administration process, and then the other set of children find out, and then they go to the court and challenge it, and then that derails the process even longer than it already takes, right? So get legal clarity. If it's a case where all the children live overseas, which is quite common, and maybe only grandchildren are residing in Jamaica, the grandchildren might have to get power of attorney for on one of their parents, and then apply for the letters of administration that way, right? But there is a way to get it done if there is no will in place, right? So another scenario, what if somebody inherits a house and wants to sell it right away to pay off debt? So you know that you inherited the house, there is some kind of will in place, there's some documentation in place, and the person wants to sell it right away to pay off debts. What can they do? Well, not so fast. If it's not a trust deed that's in place that indicates that you are the beneficiary, then you cannot just sell it off the bat. You have to go through the probate process. So the will indicate who the executor is, rather. And after identifying who the executor is, if the executor is alive, then they will assume their role to administer the estate, get the grant of probate, and then go through the process of transferring the land to whomever the beneficiary is. So you can't just sell the land outright, because it's not yours. It's still in the name of the deceased persons. So you have to follow that procedure, right? There may be situations where parties can come to an agreement where an interested buyer, for example, wants to secure their interest. So maybe they'll agree to rent the property temporarily, and give the rent to the executor, for example. And then while the probate process is going on, so that when it finally finishes, they know that they can be the first person to have the option to purchase. But you can't just sell something just because you're the heir. You have to go through the probate process to officially put the thing in your name. So another scenario, remember guys, please share the live, and if you have any questions, you have the option to come up as well, right? So scenario 3, absent beneficiary holding up the sale. Imagine several siblings are ready to sell a piece of inherited land, but one brother who migrated 20 years ago is unresponsive. How does the law deal with an absent beneficiary? So the good thing is it's a beneficiary and not an executor. For instance, the process can't go anywhere without knowing what the status of the executor is. But if it's a beneficiary that is unresponsive, The administrator or the executor for the estate will simply have to go through the probate process and then uh, transfer to the persons who are responsive and make sure that they put something in place so that that person's interest is protected. So for example, if you have cash or somebody passed away leaving stocks or money in bank, they have to divide up everything equally among all the beneficiaries, and then they have to create a trust account to hold things for that person, because even though the person is migrated, they may fall on hard times, or they may need money, or they may have ill health, and then they may want to actually reach out and claim what is theirs. So just because somebody is unresponsive, it doesn't mean that you can give away their birthright. It doesn't work that way, right? So if it's somebody who is unresponsive, you have to put aside what they're entitled to. If it's a case where it's a house though, and everybody wants to sell the house, then things may get a little bit more complicated there, right? But you can't give away somebody's birthright simply because they're unresponsive, or you can't get them on the phone or whatever. The fact that you have evidence that they're still alive, the administrator or executor of the estate has to do the right thing. Scenario 4, and this has to do with unregistered land. We want to sell, but the land has no title. Very common scenario in Jamaica, because we have a lot of unregistered land. A lot of families inherited property from indentured servants' time, or times when or great grandparents were freed, and they had access to land, and it passed down from generations to generations, or the land was bought with a simple handshake or like a receipt, with the knowledge or not that the buyer would have to take the necessary precautions to actually purchase the property, to get a proper title for the property. All right, so what can you do? So Jamaica does have a process for unregistered land to come under the Registration of Titles Act. So the Registration of Titles Act is what allows land to be officially recognized on record. All right, somebody has a comment here. Not give away the birthright, but in the case of property, how do you recover things like property tax? All right, good question. So when it comes on to any inverse you. All right, so if you want to come up, just please leave a comment or indicate that you want to ask a question before I allow you to come up, please. This ties into a question a client of mine asked me recently. They had to pay the stamp duty to get some things done, and they wanted to know if they can get their money back. And my answer was yes. So if you pay something on behalf of an estate, it's like a loan to the estate. So you're entitled to get your money back. So if you pay the property taxes, if you paid up the estate duties, you're entitled to get your money back. So the executor of the estate, or the person who is the administrator for the estate, they're supposed to pay all of the debts before they transfer any interest to anybody else. Right? So if it's a case where the only asset is real estate, then the family can probably decide to rent it out or to lease it so that some cash flow can be generated, and that will allow everybody to be reimbursed for whatever expenses they would have incurred on the estate's behalf. So that's one thing that can be done to recoup money. So on the topic of unregistered land, okay, Silaman, but if the person is non-responsive, you just have to put away their interest, put it aside. It depends on how many people there are. So if it's like 5 siblings and one out of the 5 unresponsive, that person's share will just have to be put aside. If the person that's unresponsive is the executor, then I can see where the dilemma is. You'd have to get a court order to have that person removed. But if it's a recipient, if it's a beneficiary, a regular beneficiary that doesn't have anything to do with the process actually going through, then you just have to put aside what they're entitled to. So if the property is sold by the executor, for example, or they lease the property, that person's money has to be put aside in a trust account because they can end up suing. Um, they can end up suing. They can end up suing the executor or the administrator. You can be sued. Well, the administrator or the executor can be sued, right? So, just to repeat, let me just also to refresh myself about the other scenario I was gonna get into. But great question though about what can be done when they're unresponsive. All right, so we can know address an issue that many overlook. A family wants to sell ancestral land, but the title was never registered. Only outdated common law deed exists. What are the complications here? So this is similar to what I was saying, where persons inherited land from, great great grandfather, or somebody goes to country and sees a land and they find out that Mastro is the one that own it, and Mastro can speak to, how we ended up owning it and say, give me $10,000, and they have a handshake and maybe they write up some kind of receipt. So Jamaica does have a process for unregistered land to operate under the Registration of Titles Act. And that's the act that recognizes property on record. You get a nice, what's called a duplicate certificate of title. So there are a few important things. It is not a process that is without expenses. Yes, obviously legal fees apply, where you're getting the support from an attorney. But you have to engage a surveyor and you have to identify persons who can speak to your ownership. So those are the two major hurdles. However, depending on where in the island you are, the government has actually made the process very affordable for some people from certain parts of the island, where they actually sent out field workers to do the relevant investigations on ancestral lands, and assisted persons to get their title. So depending on where you are, typically it's rural communities where persons inherited land and the government has put provisions in place for persons to get their title. So they just pay like a small fee to cover basic administrative expenses, but that's a very limited places. So if you're in a rural area and you have land and you don't have a title for it, you may want to just check to see if your community is among the areas where the government was actually assisting persons to get their title over the last couple of years. I think that program is on the tail end right now, but you can reach out to the National Land Agency about that. Now, for the people that don't have that benefit, as I said, you would need to engage the services of an attorney to help you with doing the relevant drafting, and also you have to factor in the cost associated with getting a survey diagram. As it relates to the cost to do this, typically when it comes down to anything real estate in Jamaica, the fees are determined by what the value of the property is, and attorneys typically charge a percentage of that. That's typical, but there are other fee structures that can possibly apply, but just bear in mind that it's typically a percentage of the value of the property, right? I'm gonna go to another scenario now. Scenario 5, squatter turned owner. I pay the taxes every year, so it's my land, right? Does this also involve root of title investigations? You mean from the perspective of what the attorney does for persons? If it's from the perspective of the attorney, yes, that is something that we also have to do our due diligence and fact check, because the reality is people can come up with a myriad of stories and scenarios. So we have to do our own due diligence. So if I say to somebody, can you produce 2 to 3 people or even 4 persons that can speak to the root of title, right? If your family is the original owners, or if you're gonna say you purchased it, I would also, me and my team and like the surveyors and people that we use, they would need to have, satisfy themselves. We need to satisfy ourselves that this is a legitimate situation, because we are obviously not going to be facilitating any kind of fraud with anybody. So we have to satisfy ourselves that this is a legitimate application for registration of title. That's very, very important. A lot of people are, do unscrupulous things as it relates to real estate. And so we have to make sure that we maintain our professional integrity. So the search is very important for sure. Because other than like the full issue of fraud, you have instances where a surveyor would go to a property because they have to give notices, and the surveyor is attacked by the people that are there. So somebody would allege that, hey, this is my family's land, and then when the surveyor goes there, the surveyor is being attacked with machete, or a crowd comes out, and you don't want your professionals to be in a situation like that. So we have to do our own due diligence. The annoying thing though, sometimes it's like if the application is being done for remote areas, sometimes people won't speak up about like boundaries until they themselves are doing their own application. So they'll see a neighbor doing their process, get the notices from the surveyor goes and do their thing, and they have no comment, no objection, no nothing, until their family is attempting to do something, and then you hear, oh, the boundary is not how it's supposed to be, etc. And that derails the process for everybody else, and that's very annoying. When nobody responds to the notice, yet still they have thoughts around what the appropriate boundaries are. So that's a huge inconvenience, because the survey diagrams can take up to a year depending on when it was submitted. Depending if it was submitted like during a peak season. Well, when you come on to real estate in Jamaica, every month is a peak season, but some months are more busy than others, and then something gets submitted, and then your diagram is almost ready, and then some neighbor is like, oh, oops, the boundary is not right. That's like so annoying. I That's a good question, but why not use technology in terms of the survey? That's a good question, and I feel like those professionals need to figure out how they're gonna better use technology to support their diagrams, because it can be that you as a surveyor, you are looking for pegs, and I'm just like, but if it's unregistered land, like there's no guarantee that there's gonna be pegs. And so you have to rely on people who live there, people in the community that know that, oh, Mr. Brown and Mrs. Brown, they've been using this acre, or this has been their boundary for a number of years. So they have to figure it out. But I think there still will be limitations, like especially instances where there's no pegs and they have to rely on neighbors to actually verify. Neighbors and the owners have to verify. So it's not a black and white thing, you know. So we're gonna talk about the people that are squatting and think that because they pay taxes they automatically own the land. Doesn't really work that way. So if a man has been living on a land for 15 years and has been paying property taxes, the original owner has migrated, can the squatter claim ownership? Yes and no. There is a high threshold to establish, but the law does say if you leave your land careless for 12 or more years, consecutively, 12 consecutive years and more, you have somewhat abandoned your property. Then somebody who has been in possession for 12 or more consecutive years, they may have a basis to claim ownership and may be able to get a good title. Property taxes is a small part of demonstrating ownership. Possession is another is an important thing. And by possession, you have to demonstrate that you are your owner, you intend to own. Everybody knows it can be possession in secret. Everybody has to be known open, undisturbed. And so the owner should not have given you permission. So it has to be undisturbed possession for 12 or more years. So property tax is not the only thing. What I say to my clients who are overseas, because typically my firm works with Jamaicans overseas, you have to put little things in place, right? So you have to come to the property. You have to make sure that you have somebody in place that is debushing, right? You want to possibly put up some fencing. So you invest in some barbed wire fencing. You want to invest in things like no trespass sign. You may want to have a dog, and you pay somebody to make sure that the dog is fed and that sort of thing. Different things can be done to demonstrate that you have not abandoned your property. But what about instances where the property is very large, like it's several acres? How do you treat with that? Well, if you have a property that's say 50 acres and one of the acres people living on it and you don't know, I don't know what you kind of. So why is it 12 years for private lands but 60 years for crown lands? I don't know what the thinking was with the crown. There isn't really a lot of language to establish what the train of thought was. But really and truly nobody owns anything. It's the crown that really owns everything. I think they just want to make it not so easy to disrupt any good title owned by the government. But at the end of the day, technically, if the government says to you that they want to take over property, they have the option to do that. So if the government decides that they want access to something for a road or whatever, there's really nothing stopping them. You know what I mean? But most of the let me not say most, a significant number of cases around adverse possession. Usually people are living on those properties for multiple decades. Is usually not the bare 12 years. Yes, but with some areas, regeneration in terms of crime, your access can be effectively denied. And I can give you a scenario. So I had a client, somebody living overseas again, back in the days, and I'm talking like 4 or 5 decades ago. the property that she owns or her family owns was middle class, middle income. And then, with, as you know, we had a lot of political instability in a certain era, and people fled. And so the properties in that area, were really overtaken by certain persons, and then violence and all of that stuff, etc. And when she wanted to reassert her ownership, I personally received threats. And when I communicated, what would be required, because based on the context, we thought that once these persons got notice, they would have, made arrangements to move and so forth. But they were putting up a fight. And the reality is, once the original owners take action to demonstrate ownership, the time starts to run again, right? Unless the persons who are claiming adverse possession would have taken steps through the court or through an application of their own. But I personally received threats. And then she was like, look, it's not worth it, And so it's sad to me, because we see that a lot of gentrification is taking place. We see the development that's happening downtown. The government and investors are very much serious about developing downtown and surrounding areas. And for somebody to just be like, oh, it's not worth it, it's kind of sad that they opted not to really push. But you are certainly right. By virtue of violence, sometimes owners are invariably denied access. And when they consider whether it's worth it or not, they may decide that it's not worth it to fight it, because legal fees and the effort and the stress and all of that. All right, so guys, as I said, you have the option to come up and ask any questions that you may have, and I can give context where it allows. But I'm going to go to another scenario now, where persons build on family land. Reading a comment here. This process is so unfair. You have 12 months after date of death to probate an estate before you think it's start to incur penalties. I don't know that. Why you think that's unfair though? 12 months, you can start the process, if it's even a botched process, until you get a lawyer. I don't know that I agree that that is unfair. In a sense, where you're grieving, it's kind of difficult to be thinking about legal processes. And I can really sympathize with persons who are overseas and for various reasons they can't travel, and so to be thinking about immigration related issues, plus issues related to the funeral expenses. And then maybe there's a family drama, people not working together to decide who's going to administrate the estate. Maybe the executor passed away. So I sympathize, but I don't know that I'd say it's unfair that after 12 months, the estate starts to incur expenses if they don't settle or if they don't administer. I get you. So if the government can give squatters 12 years to have free reign, why they can't give regular, people who have a legitimate situation dealing with 12. I get what you're saying. Never really did that. I never really juxtaposed that before, to be honest. But I hear what you're saying. Yeah, if a squatter can have 12 years to establish good title, 12 years is a long time. Why can't you get a clear 12 years? I don't think 12 years is reasonable. Remember, estate duties globally, not just Jamaica, estate duties globally, that is a major cash cow for governments, right? Comment, question, how do you determine the interest rate on a mortgage that was issued by a person on a title? Well, the title itself has a lot of information on it. Why is the why is the owner, why don't they have that information on hand? When you say a person, who is that person? Because if you're the buyer, you just get that information from the mortgage company. Oh, I see. Okay. I'm going to answer that question, but this is why it's important for persons to get life insurance when they're buying things like real estate and any other major assets. Because if they had insurance, then the insurance would have pay off that mortgage debt right away. So I know there is a certain bank in Jamaica, won't call their name. They don't insist that their borrowers have life insurance that matches the value of the property. But for me, I think that it's important that persons, once you're deciding to buy a property, if you're going to that certain bank that don't insist that you have the life insurance, please at least get the cheapest one that you can find, because you never know, right? My family personally, that's what allowed us to clear off the debt associated with our family home. My mother had life insurance, and when she passed untimely, because it was something that was a requirement based from the agency that she bought the property, we only had to find a few $1,000s to clear the debt. So I would highly encourage that, okay? So just bear that in mind for persons who are on here that want to buy a property. But to the question about how do you know what the interest rate is? All right, so unfortunately, you can't just go ahead and ask the mortgage company that unless you are acting on behalf of the estate. So the executor may possibly write to the mortgage company and be able to get that information before getting a grant of probate. If there is no executor, meaning no will was created by either parties, then I do not see the bank giving out that information until the estate administration process is completed and the administrator can write in their capacity to get that information. So I don't see a bank, because of confidentiality. I don't really see that happening. But the executor, if they had a will, could try their luck and see if the bank would give that information prior to the probate process being completed. The process is long and now stuck at Accountant General. Oh, I see. Yeah, I mean, it is what it is. But that's why whenever you are whenever you're doing certain things, right? If you know somebody is mainly a criminal lawyer, it wouldn't make sense to go to them to get a probate done or to do your conveyancing if you know that their specialty is criminal law, if that's what they're known for, right? It's important. One of the reasons why you go to attorneys that are known for a particular thing is because we may know different tricks to the system that an attorney at those criminal law may not know, right? So sometimes we, as the attorneys at the conveyancing and the probate and the estate, we have gone through the trial and error process early on. So your case won't be a trial and error process. You know what I mean? Do you do divorce applications? Yes, we do divorce applications. I am actually offering 15-minute case clarity calls So a 15-minute case clarity call where you speak with myself. So I'm the lead attorney at Law Boss Firm. So you have a conversation with me where I just figure out, or we figure out together what your situation is and the urgency behind it. And then if you decide that we're a good fit, or if we both decide that we're a good fit, then we can take it from there. Uh, so when you say timeline, do you mean the timeline of how quickly a divorce can get done? So if you do what you're supposed to do as a client and you don't come with no complications in terms of when we ask you for information, you provide it promptly, then your divorce can be done within 6 to 8 months. But if your matter has complications like the person doesn't live in Jamaica, you don't know where they live, you don't know where to find them, you don't know where they work, it's gonna take some time because we may have to do some additional applications in addition to the regular process. No kids, no division of property. If I had $1 for every time somebody say them divorce simple because there's no division of property and no children, I'll be rich right now because I've never encountered a legal matter that is simple. I've never. I'm telling you. Everybody think their situation is so simple, and then they come to me with some weird thing, and I'm like, okay then. Or there's no division of property, and then all the children are adults, but then somebody don't like what is said in the petition. Oh, I don't like what he said. I don't like what he said about me. I need it to be changed. I wish, honestly. Oh my God, I wish. Yeah, so in the context of divorce, the 15-minute call would allow for you to speak a little bit about just have some, why it's important for you to get it done now, as opposed to next year, for instance, and whether or not you're in a position to actually pursue the divorce. And then our team, we have a intake form that you complete, and we have another form that you give us, the complete details about the breakdown of the marriage and stuff like that. So even if there's no division of property, for example, we still need to know where you lived as a couple. Certainly little details are important. So that's a part of the the official consultation process that you would go through, but the 15-minute call is there. I'm going to put my, oh Lord, I don't know how to put comments. Oh dear. Every time I figure out something to do on TikTok, then there's something else, and then I just don't. Oh my God. I used to be able to put comments down here. Why am I not? Okay. That's not what I wanted to pin. I wanted to be able to put the cell number that you can send a message to book the call. But if you send me a direct message, I'll send the contact number to you. Once you send a message to the number, you automatically get a message with the link for you to schedule your own 15-minute call. Yes, you can inbox me, and I'll respond with the number that you send a WhatsApp message to, and you automatically get the link to schedule it. So you schedule the time that works for you on a Monday, Wednesday, or Friday, and I give you a call. All right, so the other scenario, or somebody say, can I join your box? So you want to come up and ask a question? If it's a case where you want to come up and join and ask a question, you can do that. Yes, I don't know how to do it. Uh, I oh Lord, you have to request. Oops! Oh, do it again. I just saw you come up. Sorry. Do it one more time. I think I just saw it come up. Guys, how do you do this? Oh my God, I'm gonna have to figure out all of these things, you know. I think you click on the thing, click on the top right corner. Anyhow, yes, if you want to come up. Oh, I see it now. I see it now. Okay, good. Okay. Okay. All right, I figured it out. All right, go ahead and ask a question.
Okay, good afternoon. This is not like a divorce question.
Sure.
Since it's I need an attorney, I want to know how could I
Hold on. Repeat.
taxi
Start from the top.
taxi? How do I structure how do I structure the business that the estate owns the limited company and it doesn't have anything to do with me?
All right. Do me a favor and start from the top, please.
Can you hear me?
Start from the top, please.
All right. Okay, so can you hear me now?
Yes, much better.
All right, wonderful. So this is not divorce related. I want to start a taxi company. How do I structure the company that I don't have any affiliation with the company, but the trust owns the limited company and not me?
Okay, so a limited liability company has its own legal. It's a legal entity in and of itself. So I'm not sure what the idea is between if you plan on setting up a trust. I'd love to know what the thought process is behind there being an established linkage between the limited liability company and the trust, because those are two separate legal entities that have their own unique protections, and I don't know that you need to mix and mingle them. And it depends on how the company is set up as well. So if is the company gonna have shares, and then maybe the shares are issued to beneficiaries who are in your trust. I suppose it could work that way, but if your intention is to have a separate legal entity where you are not, you can't be sued, because that's the idea. A taxi company is a high risk sort of business, and you want to maybe have the company have its own insurance policies and its own liability protection. So I can understand that, but I don't know that you necessarily need to merge the two, and that's something you'd probably want to I could consult with you on over a
Okay.
call to decide how to figure that out. But
All right.
a company, there's a lot of protection that the limited liability company affords here in Jamaica, and that is something that my office does offer support with. So the setup, and if you're interested in creating a trust, we also have offer support there. And then from the creation of the trust, you can even have a separate trust account where monies from assets that are gonna be a part of the trust, it can go into that particular account. So I don't know that you need to stress about merging, having any sort of merger. If you want to just get your company off the ground, you can put certain separators Yes, somebody here is making a very good point, but under certain circumstances, the veil can be pierced, and the veil being the corporate veil. So in Jamaica, um, there are some upsides and some downsides to how developed our system is, right? So in Jamaica, when you're setting up a limited liability company, you can have one director, but if you're gonna have one director, you must have a separate secretary for the company. So that establishes the separation and establishes the company as a separate legal entity. However, if you
I
treat your accounts like they're your personal accounts, then it's gonna be difficult to communicate to anybody in the court that is a separate legal entity. But go, you had a question, another comment?
all right. So my I'm in the US, right? And in the US, you can you let's say you register. Let's say you have like a holding company in say St. Kitts, right? Or even states like Wyoming. You do not have to disclose like an individual identity in association with the business. So in the case of a divorce, technically I own nothing, right? I own nothing. Nobody can come for anything. The trust owns it. And the American government is a trust in itself. So that would be a trust against a trust. An individual cannot go against a trust. You know what I mean? So what I'm trying to see if in Jamaica, like how a certain political representative structure his or her company, right? That you look and you know that these people are associated with this company, but there is no document to say that this person is associated with the company because there's a holding company, there's a trust that monitors this thing, so there's no individual per se.
So, Caribbean Business Review has raised a very great point here. Remind her of the rules governing beneficial ownership. So, as I said, there are some upsides to Jamaica being the way that it is, and then there are some downsides. So, once you have a separate legal entity, a limited liability company, that's what it is. Our structure is not as complicated as the US. So
Okay.
I know for a fact that you can have a limited liability company in America, and if it's only one person operating, the tax code will recognize it as the same thing as a sole trader.
Yeah.
Right? So you have to take the next level of whether you're doing a S corp or a C corp, and there are financial implications with going that route, financial and taxation obligations associated with that. So it's not a clear cut thing, which is why CPAs charge what they charge in America, because if you want that layer of protection, you have to pay more and determine if it makes sense for you. So now the government has come up with this thing called beneficial ownership, where you have to disclose, like at the end of the day, who is benefiting from the proceeds of this company. And so, because of the whole thing about beneficial ownership, it then makes it important for a director or directors to perhaps, rather than treating the company account as their personal account, probably giving themselves a salary, for example, and it's clear that this is their salary, right? And whatever their salary is, that's what they own, or that's what they have access to financially. So if somebody wants to say that, well, is a limited liability company, but they only have one director, but the director can say, well, over the past 5 years, my salary has only been $1,000 a month, for argument's sake. And so my asset base would be reflective of that modest salary. So it's not a black and white thing. And when people make reference to like political representatives, you have to remember everybody's scenario is different, everybody's situation is different. And just because you know that a person is associated with something, it doesn't mean that it's true. The media has a way of spreading rumors. But yeah, if you send me a DM, you can we can set up a 15-minute case clarity call and see if my office can assist you further. Well, thanks for coming up, though. I really appreciate the comments, and I hope you got value from what we discussed here.
Alrighty then. Thank you.
Cool, cool. All right, so want to address another scenario. Other scenario that I was getting to, building on family land without a title. So one person built a house on family land, but now a sibling wants to sell. She has no title, no what. So scenario is somebody built a house on family land, sibling now wants to sell, but there is no title, no what. That's a very complicated scenario because one, there's no title, but two, how do you defend the ownership or the value that you added onto the property? So it's really not wise to build on family land unless you have some kind of documented arrangement in place, so that when the time comes to explore registration or title, one, you have the support of all the family members, and two, when the title is ready and if the family decides that they're selling, you can recoup whatever you would have invested in the title. But the common scenario I see where people build on family land is when it comes on to like a husband and wife. It's usually the wife building on land that she had access to through her husband, right? And yes, permission was given, but then there's no documentation that she got permission to do that. And so no, but in terms of recouping expenses, there's no guidance around how she's gonna recoup that. And then they separate and then the money just blow up just like that, So it's difficult for a spouse or a partner to claim any kind of beneficial interest in property that their spouse owns with somebody else. So it would make sense if you are thinking about investing in family land that way. Just have some kind of written agreement in place. If you have money to build, you must have money to speak to an attorney to draft up some kind of agreement, so that if anything happens or when the time comes to secure the title and money needs to be spent, you can recoup your expenses. But it's not recommended to build on family land. And if people get uncomfortable about putting any kind of documentation in place, then you have your answer about how they will position themselves, if you have a conflict, you know what I mean? So if you have any questions around real estate, estate administration, probate, you may come on and ask any questions that you may have, and I can offer any clarity where the context allows for that, right? So the other scenario that I want to look at, how do you, similar to the one I asked earlier, how do you deal with an inherited property when somebody comes out of the woodwork 30 years later claiming a share? So just like, earlier when I spoke about the heir that was unresponsive, what if, many years later, they come on to the scene and say, hey, I'm actually entitled to this thing. Well, one, again, as the executor or the administrator of the estate, you can't just take people's word for it. You have to do your own investigations, because depending on the type of person that owned the estate initially, it could be like somebody from another family. I don't know if anybody used to watch Royal Palm Estate. So there's this show called Royal Palm Estate. It was like, or Jamaica's version of soap opera. And there was a famous guy in the show. For the life of me, I can't remember the character's name right now. But he was very wealthy. And then it's the person came on and they were like, "Oh, Bob Marley is my father," kind of thing. And the person was like, just imagine you're saying Bob Marley. So the character in Royal Palm was like a Bob Marley type of figure. And the person was like, "Oh, Bob Marley is my family." Oh, Blackwood. It's Blackwood. Anyways, nobody on here watch Royal Palm Estate. Anyhow, the person come on the scene and was like, "Oh, Mr. Blackwood is my father." Blackburn. Right, somebody was like, "Oh, Mr. Blackburn is my father." Obviously, Mr. Blackburn is very wealthy and had a lot of assets. And the person was like, "Mr. Blackburn is my father." And Tanya was the name of the wife or the widow who married Sonny T. She was like, "Oh, she didn't believe," and she got a private investigator to verify whether or not this person claiming, they were a Blackburn. Obviously, it came out that it was like a fake thing and they were trying to commit fraud, right? So if it's a situation like that where the owner of the estate had multiple, was somebody known to have a lot of women, you want to do your own investigations, obviously. But if they're claiming to be a beneficiary, if there's no will where their name was explicitly mentioned, then you want to take the necessary precautionary steps, and they have to come with some kind of evidence to demonstrate that they in fact are here, right? So this is why it's important to go through the probate and administration process as early as possible, because once executor does their due diligence, does their job, once an administrator does what they're supposed to do, if it so happens that all the assets are distributed, in the way that they thought they were supposed to do, if somebody comes out of the woodwork that was not mentioned in the will, or that, their name did not come up while they were going through the estate administration process, you won't be at fault if you happen to be the executor or the administrator, right? But if you knew that there was a long lost love child, and it can be proven that you knew about that person and you still decided to share up everything and exclude that person, then you could potentially be sued for doing something like that, right? All right, so another scenario that I want to address, and this will be the final scenario that I deal with for today in the legal lounge. Ownership versus occupation. So I would have been speaking about that. I spoke about that earlier when we addressed the comment or the scenario about squatters and the 12-year period. So imagine somebody legally owns her home, but her ex still lives there and refuses to leave. What are the legal options in such cases? So again, imagine a woman who legally owns her home, but her ex still lives there and refuses to leave. What are the legal options in such cases? All right, so this is a very loaded question, right? Because ex could mean ex-boyfriend, somebody that she's known for a couple of months, and they're living together. In a situation like that, she would have to go through the proper channels to evict the person if they don't want to move out. Probably get the support of the small claims court, serve them a proper notice, etc. But if X means common law, so in Jamaica, we recognize common law. If you're living together with somebody for 5 or more years, that person is recognized as your spouse. So if X in that context means common law, then the rules around ownership and the amount that you'd have access to applies. If X means husband, then the necessary steps would have to be taken. Well, they'd have to go through a divorce and then a division of matrimonial assets, etc. So that's a very loaded question. But bear in mind, if you're in a common law situation, there are very similar rules around ownership. So If it's 5 or more years, somebody can say, hey, this is a family home. And because it's a family home, I'm entitled to certain things. It is what it is. So people really do have to be careful about that. The unfortunate thing, though, if it's not a common law relationship, boyfriend girlfriend type of situation, you're going to have to give the person notice to quit. And then if after 30 days they decide that they don't want to leave, then you'd have to take that extra step of going to court. And some people are really that petty, you know. But I've never really seen something like this play out in Jamaica where a boyfriend don't want to move out. This is really a thing that I see in the States, but you know, we're living in strange times, so bear that in mind. Obviously, if it's a married couple and the woman owns the property before marriage, she can't just get up and say that she's kicking the man out. It doesn't work that way, darling. It's not considered a family home, right? So if you have any questions before I head off around any of these issues, you can ask to come up and ask a question, and if the context allows for it, I'll answer and share whatever general guidance I can share. If you send me a direct message in my inbox, I will respond with the contact number that you want to send me a message to say hello. You get the link to schedule a clarity call with me. So that's a free 15-minute call where I can see if my firm is the right place to support you with whatever legal challenge you may have, and to see if we're a good fit and to really look at whatever the urgency of your situation is, right? So you have the option to do that. And then after the call, if you decide that a consult is the right fit for you, then you can go ahead and do a consult. So before I head off, I'll just do a review of some of the key scenarios that I discussed today, right? So we looked at what can you do if somebody passes away. Okay, where are you located? So our office is in Kingston, in the close proximity to the New Kingston area. So we do consultations and meetings with clients in person, but a lot of our clients, not sure what the LOL is for. Okay. Most of our clients are people that are in the diaspora or they're living overseas, and we do have capacity to help persons who are overseas. So it really doesn't matter where in the island you are at. Or consultations, we typically do them on video call so that at the end of the meeting you can get a recording of what we discussed and you can relate to it, to refresh your memory about what we discussed and the plan of action that we established. So our consultations are not like a little quick chat that you have. We really ask you to share information before you and I even meet. And at the end of the call, you're left with a plan of action to move forward, right? But I thank you for all the persons who came up and asked their question. I appreciate the engagement. Thanks for coming to the Legal Lounge with Law Boss. My name is Sophia Bryan. So in terms of fees around consultations, it depends on the type of matter that you have. So that's why the 15-minute call is important. So we talked about the land registration process. And I shared with you that if you live in a certain rural community, the government may be assisting you with getting your proper title. I spoke about the fact that paying taxes is only one aspect of showcasing ownership. And I gave you some other ways that you can showcase ownership if you're overseas and you don't want to leave your land careless for squatters. You can put up a fence. You can probably get a dog and have somebody take care of the dog and the dog watch the property. put up your no trespass signs. There are a myriad of things that you can do, right? I also spoke about what can you do if you have an heir to an estate that's unresponsive. I made it clear that you can't just give away the person's birthright. You can be sued if you're the administrator of the estate or the executor. If it can be shown that you took the step to give away what that person has, you're supposed to create a trust account and put aside whatever proceeds that person is entitled to get, right? And we did speak about a little bit about divorce and the fact that it's never a simple black and white process. Even if there are no assets to be divided, even if all the children are adults or there are no children, everybody's situation is unique, all right? And as I said to you before, if you want to have a 15-minute call to see if my office is the right office to support you, you are free to do that. So I am signing off now. If there nobody wants to come up to ask any questions, I'm gonna be exiting the lounge now. Again, my name is Sophia Bryan. Thanks for joining me. And the contact details are on the page for those of you who want to get in touch with an attorney. Bye.